You need to consider and imagine how best to explain your opinions to a layman who you would be addressing as a juror during your testimony. Conjuring up new visual design and exhibits, usually called demonstrative exhibits, is your job. These exhibits can take different forms, and the choice is up to you primarily, although you should listen closely to suggestions or comments from your attorney about their effectiveness with the jury. You should also know that the jurors may bring the exhibits you prepare into the jury room during their deliberations. You should design your exhibits with this in mind. They should be easy to understand and convey a precise message that you want the jurors to understand. Correlating a single exhibit with a single opinion is an excellent strategy, particularly if you have multiple opinions you're presenting. Some ideas for your exhibits might be, first, a colorful graph to represent boring and otherwise extensive data. You can use this technique to summarize a large quantity of data in an easily digestible way. Each graphical summary should be completely accurate. If the graph that you create is new and creative and meant to be symbolic of a portion of the data, show it to the attorney and others on the team. Ask them if it is clear and if it accurately depicts the data that you are using. A video of a laboratory model or reconstruction of an event is another possibility. By showing in court a video of your mode or reconstruction, you can better control the overall conditions and avoid potential problems in the courtroom with equipment. You could use blow-ups of photographs or maps or medical films such as x-rays. These are completely factual, well received, and can guide the jury engagingly to the precise visual nature or location of the facts that you want to discuss. You can also use an exhibit to highlight a small portion of numeric or textual data from other evidence that has been introduced in printed form already. Whiteboards, blackboards, green boards, or overhead transparencies are low-tech devices that you can actually write on to make points during a stand-up presentation in court. In order that they look completely professional, your attorneys will probably hire somebody else to prepare the fundamental exhibits. You must design the exhibits in advance so that whatever is prepared for you then, there's enough time for the people to prepare them. You have to review them, though, to ensure that they have been created correctly and according to your instructions. If appropriate, you should test them to determine if they are readable enough, colorful enough, and quickly and easily understandable. You also have to prepare the exhibits far enough in advance so that they can be shown to opposing counsel well before the trial. If time is limited, or if you are not confident that the attorney has personnel to prepare your exhibits, then you should hire your own graphic consultant to prepare those exhibits for you. Remember, though, that the exhibit has to be of your design to demonstrate your data or metaphor or other information. Even if someone else, though, prepares the physical exhibit for you, it's still your exhibit as long as you oversaw or directed its preparation. Your attorney is ultimately responsible to ensure that the exhibits are admissible to the court as evidence. He has some legal hoops to go through, such as obtaining either a stipulation from the opposing counsel or a court order approving them for use during the trial. You must verify, however, that the final exhibits are accurate and that they are similar to the precise subjects they represent in the litigation. That's important. Work with your attorney. Between the two of you, you have to make sure that your demonstrative exhibits meet this important criterion. An important tactic to take away from this, then, is that you should review any exhibit concepts with your attorney in advance, before money has been spent, to make sure that each exhibit contains the proper foundation for your use during testimony.